Hello, everybody. This is Robert Barton here at North Carolina State University. I'll be hosting our webinar today, Heirs Property, Standing on a Lot of Love, Part 2, a deeper look at strategies for heirs property owners. A couple little housekeeping things before we get started. First of all, I just want to remind you, if you have joined today's webinar for continuing education credits, we ask that you complete the whole process to receive those credits, and that process involves completing our satisfaction survey at the end of the webinar, taking and passing a short quiz, and then completing the online continuing education form and certifying that you participated in its entirety. Once you do that, you will receive in your email a certificate indicating that you've completed the process and awarding you the continuing education credits. The information that we've gathered at the beginning of the webinar will be sent off to the Society of American Foresters to register with them. Let's move into, let me introduce our speakers today. We have two people presenting today, Sam Cook and Mavis Gregg. Sam is the Executive Director of Forest Assets here at North Carolina State University College of Natural Resources. And Mavis is the Director of the Sustainable Forestry and African American Land Retention Project. Mavis is also a founder of the Gregg Law Firm, in which she assists her clients in estate planning, estate administration, and heirs property matters. Before I turn it over to them, I just want to remind you, if you have questions for our presenters today, we'll be taking those at the throughout the webinar, but we'll be answering them at the end of today's presentation. So to give us your questions, please type them into the Q&A feature that you can click on the button at the bottom of your screen, and you should be able to enter your questions then. And with that, I'm going to turn it over to Mavis.
Hey everyone, I'm going to switch over to our slides. Thank you, Robert, for having us again, and thank you all. Some of you may have attended the first webinar on heirs property. There is a pretty enthusiastic response and request for a second version. Robert, pro tip. So if I'm sharing my screen and trying to, oh, never mind, I figured it out. Okay, so just to do a recap, when we talked the first time, we talked about what heirs property is and how it has been used to support families in having intergenerational wealth, because through inheritance, families are able to pass down the wealth from generation to generation. And it also comes with challenges, because from a legal perspective, any owner can seek division of the property or seek forced sale of the property, and that includes third parties who acquire shares from family member owners. And so Sam and I talked about different strategies for working with families to address the legal issues, but also take advantage of the significant opportunities for economic growth and economic stability. Today, what we want to do is take a deeper look at how we put into place those strategies and how we can support the family members. Some of you may be professionals that are working with landowners. Others of you may be landowners. And so we hope that this information is helpful, taking a closer look at the legal aspect as well as the natural resource aspect. Hopefully this will give you some better understanding and help you feel confident with moving forward, whether it's through your work as a provider or as a landowner. The way we decided to approach this is to give you a fictional case study of a family that's pretty similar to families that Sam and I each have encountered through our work. You were provided with a handout, or two handouts rather. There's one handout that has the slides from this presentation, and then there's a second handout that includes the description of our family case study, in addition to some sample documents, like there's some sample LLC documents and trust documents, and some other information will be helpful to you. I'll say this again, but let me warn you that the legal documents, the sample legal documents in the handout are, one, not drafted by me, two, do not count as legal advice from me or from anyone else, and they are truly samples. You'll see some familiar names in there of fictional characters. So please do not use those documents. They're not tailored for you or for your landowners. I wanted to provide you with something that gave you an idea of what those documents look like and how they operate and how essential they are to any kind of strategy to have succession planning in your, with your family land. So let's talk about our family. Now, we are calling our family the sample family. That's their surname, and they are a fictional family. Again, in the handout, there is a full description of the sample family, but let's just go over a few facts about our family. So two siblings have approached Sam the forester about their family land with goals that include reforestation and tree farm certification. 40 acres were purchased by their parents, William and Mary, and the last deed of record for this is from this purchase in 1946, with exception for some deeds later on where the parents transferred 2 acres each to 3 of their kids. The land use has been a home place for the sample family and used for agriculture, including forestry. William and Mary are survived by 4 of their 5 children. 1 died before them in infancy, so they died as a child. And then later, after Mary and William had passed away, their oldest child, William Jr., passed away. He's survived by his wife and 2 kids. Since their brother's death, their brother, William Jr., he had managed the farm, but since his death, Ruby and Denise have rented the family farm to a local farmer who's growing soybeans and tobacco. And they've also sold timber to a guy who visited them and made them a nice offer. Their cousin wants to lease the vacant house, so the old home place has been vacant and their cousin wants to lease it. And they've never had a forest management plan or any other plan for that matter. Their father and older brother, William Jr., mainly manage the land. Ruby and Denise have a brother, Robert, and he has not been very cooperative. He's not interested in the land. All he wants are those checks. So Sam, you visited the sample family land with Ruby and Denise, the 2 siblings that approached you. And during your visit, well, why don't you tell us about your visit and how they met you and what you saw when you looked at the land and talked to them about the land.
So hello, everyone. Great to be here with you today. It's quite odd that Mavis, you asked that question from the case study, but it's kind of a real scenario. We met at a church function. It was a big picnic, and they invited me to come back and participate with them and speak to what was going on with them and the family. Now, you heard Mavis list all the individuals that was involved with the family or may have been involved. As far as I was concerned, I was looking for the matriarch, the one person that had the voice for the family. My opinion, I needed to know from that individual sort of the acreage, what things they have done. You heard Mavis talk about farming. They have someone leasing the land. They cut the timber. We talked about the acreage. I asked, did they have a survey or did they know the boundaries of the land, property boundaries? I was told they had no knowledge of it, but they literally sold timber about 5 years ago. They were trying to lease out the house. We walked through and talked about the things that I seen from visiting the property after walking the land to say, here are some things that I would recommend. Here are some things that we need to talk about. Since the trees have been cut, it's time to think about how do we put more trees on the land, which is the reforestation part of the business. Also, I said, if you don't have a survey, we need to work from where you think your boundaries are, and also look at what ways we can help you locate those boundaries to ensure that we're working on the right piece of property. I explained to them that there's this thing called the Farm Bill, and the Farm Bill would allow them to take advantage of some opportunity under the FSA, which is the Farm Service Agency, which allows some farmers and ranchers to get into the conservation reserve programs, conservation reserve enhancement programs, or an emergency conservation program, or some forest restoration programs, even down to a wetlands program. I also wanted to explain to them that they qualify for the Natural Resource Conservation Services, which provides the Environmental Quality Incentive Program, which provides financial assistance to landowners to help them in those reforestation activities. They will pay up to a certain portion of funds to, one, reimburse them that would either go to the contractor through them or to the landowner. That would allow them to either do the site prep work, which is preparing the land to plant the trees. It would also go toward if they had to put fire lines around the property boundaries. It would also provide an opportunity for them to qualify to buy the trees and find a contractor to plant the trees. We went through all those measures. We talked about what other opportunities that the state forestry agency may provide to them. So when we get to the activities on the land, I said, I would recommend we help you, one, find your local USDA service agency, which would allow you to apply for FSA, which provides the farm and tract number, which is sort of that social security number for the farmer. It allows that person as a farmer to now proceed to NRCS to apply for those environmental quality incentive programs or conservation stewardship program, financial assistance programs. This way, it gives them an idea of, first, if we get them to apply for EQIP, which provides them money to pay for the forest management plan, now they qualify, we get started with them, and then we'll come back to the land and start working with them on building out that management plan. So Mavis, did that answer your question? When we get into the management planning, a couple of things we want to talk about. What are your objectives? What type trees do you want to plant? What do you want to see growing on your land? Do you have a succession plan? Who else in the family is going to be part of this conversation? Talk about the farm lease, the things they've already mentioned in the past. Talk about what income are you getting? Should we assess the land and look at what the Farm Services Agency publish rates sometimes to talk about, here's what a good farm lease would be. Spend some time talking about, here's the income potential by growing these type trees on the land. Also, talk about the stages of when we may come back and cut, when we may harvest as on a thinning, which is to thin out some of the trees that have grown after a certain period of time, typically anywhere from 12 to 15 years of age. Talk about if there's a second thinning another 5 years later. Talk about the markets in that area. Who are you actually selling the wood to? If they decide that, you know, I just want my trees to grow back naturally, we don't want to go through USDA, we work with them on building out a plan to help make that successful. But it's key to all landowners, if you have the opportunity and the ability to apply for these funds through USDA and they can give you the financial assistance to help you, the better off you are if you are successful by planting a good stock of trees to ensure that those trees grow up healthy, they are managed sustainably, and you get a good outcome in the future. And that takes us throughout that 30 to 35 year process. Our landowners now, if we have all the family members that are associated with this process, learning this, it helps them make a better decision as it relates to clearing that title. So with this family, I decided I wanted to show them the bigger picture, ensure that now that they've already cut the trees, if they kept some of the income, how do they benefit from taking that particular piece, the portion of the funds, help go toward paying to help to get that title clear. And that's where Mavis comes in to talk about, here's what it takes to get you to start working on your title and resolving those heir property issues.
Thank you, Sam. Before I start talking about the legal part and put my lawyer hat on, I just wanted to point out a couple of things. So, you know, you had your first visit with the family and learned almost immediately, it sounds like, that there are probably some legal challenges that they need to address before they can proceed with some of the recommendations that you're going to make. But you also still provided them with a lot of information about all the different opportunities, whether they could proceed now or later once they clear title. Why is that important? When you know that there's already some roadblocks ahead.
Yeah, because I think so many families don't realize that they qualify for some of these USDA programs and services, the resources that can help them and one benefit from it. Let's assume they need to hire you and they have not cut that timber. One of the most important things we could have done is help them to ensure that we put that timber on the market, get a good rate back to them as a return to their investment, put those funds in what we call an escrow account, to whereas it's helping them now that they need to do more work on the land. They can benefit by spending some of that money on the land, spending it to help resolve the title issues, but also teaching them that it's important to take care of reforestation efforts first, and then look at how you want to invest the rest of the funds going forward. I notice that sometimes our families, they look at strictly just getting the income and dividing it up. You need to think about taxes. You need to think about what other expenses that are going to be hitting you going forward. But most critical, think about if there is a title issue that you want to resolve, why not work toward clearing that title? And then it opens up more opportunity for you through other funding agencies. One, under the Farm Service Agency, if they were during the Conservation Reserve Program and they were able to pay you to plant trees and give you an annual payment for the next 10 years, wouldn't that sound good to you as a landowner? If you were able to qualify for an easement, a conservation easement through USDA, one thing that's a requirement, you need a clear title to have the conservation easement. Would you get the title clear and you in an area that can provide you income that goes toward that easement, there's an opportunity that you may make a little bit more money that you can put in the bank and do more work. You out there, you want to do something to your house, or you want to rebuild a house. You need a clear title if you want to get a deed to your home. So finding ways to get that title clear increases your chances to make your land an asset versus a liability.
So it sounds like even at that initial visit, and even if you, with your experience and expertise, identify some obstacles, you still find it very useful to educate the families about all of the different opportunities, including the ones that they don't yet qualify for because of the legal issues. But then you explain to them how if they can address those legal issues and get them resolved, then they would be positioned to take advantage of a lot more opportunities. And that serves as motivation for these landowners. And that's a critical part of what you're doing as the forester.
Yeah, it's been critical and helpful to me as this forester to learn from the legal end of the individuals out there talking about ways that landowners can improve in providing the land resolution, title resolution, because now I can put sort of a double hat on and talk about the benefits of a landowner who has heir property issues, but talk about here are the continued forestry practices that you can put in place that can help you as a landowner benefit. It doesn't cost, you don't have to have clear title to farm. And most landowners that I run into, they can still farm the land and they grow on trees. What has been the barrier for them, they didn't realize that they can do both, or they were selling timber for pennies on the dollar and not realizing that their timber could be a pretty good market for that wood. But also there are entities that can purchase your timber legally if you do it right.
Yeah. So in addition to, in some ways, playing a counselor / motivator, it also is important in your role as the consultant forester to know which programs heirs property owners can take advantage of and which programs they can't take advantage of, and the steps that they need to take to get to where they can take advantage of it.
Yeah, and a good consultant would have all those tools in his or her back pocket, because that helps them create a customer base that's, one, coming back and responding. It allows you to go out and, one, help all clients, because you don't just want to target one potential client. If you have the tools necessary, that's one, through USDA, what the forestry commissions or state forestry agencies or even extension can provide, you need to be able to refer those individual landowners to those particular agencies that helps them. USDA has an office in every county just about across all the states, including Puerto Rico. So you as a landowner, you're already paying for it through your taxes, especially as it relates to the state forestry agency. Why not take advantage of it? You can look it up. You can Google. We provided the links at the end of this presentation that will take you to the resources that are necessary for you to help shape your thought process in advance, even before you call somebody. And that the messages that you'll see in those links will help you answer some questions that'll prepare you. So when you do reach out to someone, you can have your questions already prepared to discuss those and have a good conversation with the agencies that show up to your home.
Gotcha. Thank you for that. So you mentioned a couple of things: replanting trees, creating a succession plan, so a plan for who succeeds the current owners, and then also a farm lease, and we know that a cousin also wants to lease the house, so a rental property, a residential lease as well, are things that we want to consider. However, as you pointed out, Sam, there are barriers to that. One is that there's no confirmation of who the current legal owners are, and you need agreement from the owners to proceed with each of these options and some of the other options you mentioned. So let's look at the family tree and think about clear title. So clearing title, again, is the legal process of confirming who the current legal owners are. When we're talking about heirs property, in many cases, the ownership of the family land is transferring from generation to generation by virtue of inheritance. And people will often point to the fact that heirs property is created by folks not having a will. But I'll tell you, from my perspective as an attorney, most Americans don't have wills. And even when they do have wills, they often create heirs property through those wills because they're leaving their property to multiple owners. So heirs property really is just land owned by multiple members of a family, each of whom inherited their share. So with our family, the Sample family, this is our family tree. And again, we have the parents, William Sr. and Mary. They had 5 kids, one of whom passed away as a child, and then one who passed away after Mary and William, leaving his wife and kids. Now, the X's indicate, the X's by each of those folks' names indicates that they are deceased. We went from 2 owners to 6 owners, and that has to do with that set of laws that's in your handout on intestate succession. So in this scenario, no one in the family had wills, and so the property ownership transferred by virtue of our intestate succession laws, and that's the set of laws that we look at to determine who the heirs are when someone passes away without a will. And again, most people who have wills duplicate the same kind of scenario. So in this family, we went from 2 owners to 6 owners. We don't have information about the age of the kids, but let's just imagine, for the sake of clarity, that all of the family members, including Robert, who's been very reluctant and hasn't wanted to be involved with the family land, have agreed that, you know what, we want to ensure that the land stays in the Sample family, and we don't want it to become a source of conflict. Yes, all 6 of us agree to put the ownership into a single entity owner. And as we discussed at the previous webinar, putting ownership of heirs property into a single entity owner allows the family to create an ownership structure that's tailored to their needs. They can determine how decisions are made. When they own it as heirs property or tenants in common, it has to be 100% unanimous. If they put the ownership into an entity owner, it can be majority vote or some other type of structure that fits that family's particular needs. Like, you may have different classes of participants, and those classes' rights in voting could vary. So the family has considered, and they've determined that they want to put it into a single entity owner. And the next question is, what type of entity do they want? in practice, what we've seen, and more recently, what we've seen is that families will either put their ownership of family land into a LLC, a limited liability company, or they'll put it into a trust. And I want to tell you a little bit more about how those work. So a limited liability company structure is that you have multiple role players. So one role player, and these are key, is members. Members are the people who own the limited liability company. The other role player is the manager. The manager is the person or persons who are tasked with managing the LLC. Some decision-making of the LLC is up to the manager. So thinking about the day-to-day kind of operations and day-to-day types of questions that come up. Members, on the other hand, could have rights on voting, such as when the property is transferred, or if the property is used, the property meaning whatever the LLC owns, whether it's used to leverage financing. The members also are the ones who invest in the LLC. They have to make some sort of contribution to the LLC, and what type of contribution and size of that contribution varies from LLC to LLC, but thinking about it from a family land perspective, what is most common in practice is that the members' contribution to the LLC is their share in the real estate, the subject real estate. So the family real estate is their contribution, and their share of the LLC is proportional to their share in the family property, in the actual land itself. So to give you an example, let's say Sam and I are heirs property owners. He owns 70% and I own 30% of the family land. And we put it into a limited liability company. We put our shares. One way to approach our shares of the LLC is to make it proportional to our shares in the land, which would mean that Sam would have a 70% ownership of the limited liability company, and I have a 30% ownership of the limited liability company, because that's the value of the land that I transferred ownership from me to the LLC. I'll pause and see. Sam, do you have a question? Or Robert, are there any questions about the LLC structure before I move on to how it operates?
While he's looking, I'm just like a family member, and I'm really thinking, this LLC structure sounds good. Now I have clear title, so why don't I just say put it in a LLC?
You could do that, but I think it's important to have counseling on whether it should be an LLC or whether it should be a trust. And you also need counseling on setting up the governance of the LLC. In your handout, there's an application to create an LLC. It's called the Articles of Organization. That's the legal document that you fill out and file with the Secretary of State. However, the really key document to the LLC, and the one that has to be really tailored to your family's land and your family's needs and relationships, is the operating agreement. And there's a sample operating agreement in there. Mind you, that sample operating agreement is not specific to owning real estate in the family. I just wanted you to have an idea of the different types of terms in operating agreement. But that operating agreement, I don't think lay people or people who are not lawyers, and I'm not just saying that because I'm a lawyer, I don't think it's something that should be developed on your own. I think it takes great care and great counseling to figure out what the setup should be, because you may decide that you're going to have different classes of membership. You could have a class of members who have voting power, who are working on those subject land, the land that's owned by the LLC, who are really engaged in the family land business. And then you could have another class of members of those who, kind of like Robert, don't want to have anything to do with it. They just want that check. Well, naturally speaking, it's important that those members who are doing the work are compensated for what they're investing over and above the actual ownership interest in the property. And so, perhaps they should get compensation and then the profits are divided among the members. It may also be that you have some intergenerational differences where you have younger owners who probably aren't working on the land, maybe they will in the future, but you have older generational owners who are engaged with the land, and they need to be the ones who are making the decisions. So, Sam, to your question, simply creating an LLC is not going to resolve the issue. You need counseling to ensure that all of the right parties have put their interest in the real estate into the LLC, and that how they are participating in that LLC, if at all, is really clear through that operating agreement.
Yeah, that is really good, because we have one participant that provides a good lead-in question to one that usually a follow-up to that. Is our example indicative of the average heirs property owner or are many more complicated in terms of legal ownership? So is this like the norm, the example, or is there more extreme cases out there or less extreme?
Oh, like the family scenario?
Yeah, the simple family scenario we provided now.
Yeah.
Can there be worse,
Yeah.
like the one that provided 1,000 family members? And I've dealt with one family,
Yeah.
one heir property owners have 360 members, so.
Yeah. Yeah, so I don't want to use the term worse. I can say that it gets far more dynamic really when you have land that's relating back to a deed from the early 1900s. So if you imagine that the last deed of record is from the early 1900s, and there have been no other deeds that are on public record that demonstrate how ownership has passed, but the family tree continues to evolve and continues to grow, then yes, you can have far more complexity in understanding who the owners are, like identifying the owners, understanding how they came into that ownership. And then even with the sample family where we had 5 children, one of whom passed away as a child, so there's no share for him, but then another child who passed away and had a wife and kids. Well, just his little branch alone could bring in a lot of complexities that either increase confusion or cost or conflict. Let's say, for example, he and his wife were estranged when he died, but were not divorced. Well, of course, the other family members are going to feel some kind of way about her becoming an owner of the property. Or what if the 2 children that he left behind were minors? Well, then that's going to involve the legal system insofar as someone has to be appointed as guardian of each of those children's estates in order to do that. So the number of family member owners plays a factor in the complexity and the ability to resolve it, but the family's personal story also plays into that as well.
Yeah, and I'll echo that, Mavis, from the standpoint that as I'm out educating landowners, working with them on these particular issues, I make it very clear to them, and it comes across sort of like a joke, but it's real.
Yeah.
Every time a family member dies or a birth is brought into the family, it gets worse on either end. So waiting for something to not happen just creates more problems for you. So it's best to start working on
unpredictability.
Yeah, and unpredictability, and try to get ahead of it, because you never know when either one of those ends will happen for you.
Yeah. So just a couple more points about the LLC before I move on to the trust. With the LLC, it's also important to remember that you have to make annual filings with the Secretary of State. You have to file an annual report. For any LLC, when you don't do that, then the state can close or dissolve your entity. It's called an administrative dissolution. So how does that affect title? Well, if your family LLC, which owns your family real estate, is dissolved administratively, then the title reverts back to the owners who contributed to the LLC. So again, that can get complex too, and I think that's something to consider when you're thinking about what type of entity you want, because if you have an LLC and perhaps you don't have a lot of activity around the land, it could become easy to forget that you need to follow those requirements and keep the entity up to date with the Secretary of State. And then there are other things that come into play like taxation and shielding from from creditors. So if you have a multi-member LLC, then you can have protection from creditors of any member's share. But it's really important that you are clear on what the different liability protections are, what the different taxation protections or requirements are before you decide to do an LLC. I'm trying to come up with a clever saying, but I don't have one. It's really easy to make an LLC, but it's a lot more complex to manage one and keep it useful for the purposes of family land. So let's look at trust. So a trust is also a legal entity. It's not an entity that you have to file or register with the Secretary of State. In fact, it has a lot of privacy benefits because you're not having to tell the public how it's set up. There's, certain provisions or certain requirements in terms of engaging with third parties such as banks and even your USDA agency. You might have to have some kind of documentation about the trust. But other than that, it's pretty private. And doesn't require registration with the state, so there's no requirement for annual meetings and annual reports, so to speak. But the way it works is that you have a settlor. So here on the left of the diagram, you have a settlor. So that's the person or persons who are donating or contributing assets to the trust. And then the trustee is the person or persons who are tasked with a fiduciary responsibility to manage the assets of the trust. So that's really important to understand, that a fiduciary responsibility, you're pretty much on the hook with the law as well as with your family or, the family that you're serving. So it's not a light role, whereas members of LLCs or managers of LLC, there is some fiduciary responsibility, but the governance of it is a bit stronger with the trust. But anyway, the trustee is the person who is responsible for the assets of the trust, whether it's real estate, cash, whatever. And then you have the beneficiaries. The beneficiaries are the ones who are benefiting from the trust. And you can have various priorities of beneficiaries. The trustee can have discretion around when and how much money they distribute. There's different ways to set up a trust, a family trust. And again, just like with the LLC, it's really important to work with an attorney to create a trust that meets the needs of your family. But the idea, just like with the LLC, is that the trust will own the real estate and the decision-making will be defined by the family when the trust is set up. And that trust will then, the funds and the assets of this trust will benefit the family members or whomever you decide are going to benefit from that trust. That was kind of a simplistic explanation of it. There is a trust document in the handout. Again, it's a sample. It's not a real trust document. I did not draft it. It's not legal advice. Do not copy and paste. But I'm wondering, do folks have questions about trust or trust in comparison to LLCs before we move on? Sam and Robert, no questions?
The only question was about the Uniform Petition Act. How has it?
Oh, okay. Yeah.
How has it helped the landowners in the states that have it versus not having it?
Okay. Yeah, and I'm going to get to that when we get to the Q&A.
Yeah, and I told you we'll
all
have
right.
that there on the Q&A period.
Okay, great. Again, there's these two charts, the LLC and the trust chart, are in the handout. And they're really just meant to illustrate who the different role players are and how the asset is handled in that type of entity. But again, with heirs property, when we can confirm that title is clear and who the owners are, it's ideal to put the ownership into a single entity owner. We will talk a little bit later about alternatives when this ideal cannot be reached. So Tam, we have the sample family has clear title. They've put ownership into, or they're close to getting ownership into a trust that's in the foreseeable future. You mentioned earlier there are some things that they could start taking care of now, and then there's some things that will have to wait until title is clear and you have signatures and authorities. Could you talk about what you would have them do next, or what would happen next on your end as the forester?
Yeah, so actually I met back with them, and we held their hand and took them to one of the USDA county office. They applied for the Environmental Quality Incentive Program, but first we had to help them apply to get their farm and tract number. And that was just providing them, if they had a deed, they would actually, with a map, they would take that to FSA. New requirements now allows the landowner that have a farm that does not have the farm and tract number, they can use the tax bill, and whoever is responsible for paying those taxes. Most states have acknowledged that and accepted that as the rule. And as long as they can show that the family is involved in this work, they will provide them with the farm and tract number. That farm and tract number now allows them to go to NRCS, whereas we were able to get them and apply for the Environmental and Quality Incentive Program, which leads now to us helping them create the forest management plan. It also, we talked about some of the forestry incentive programs that the Forest Service or any other state agency offers. We actually looked at the leasing rates as compared to what they were getting, and we found rates on the Farm Service Agency website that showed published rates down to the county level. We wanted to validate if they were getting a good rate for what they were leasing it for. Come to find out, they were not, so we helped them look at ways to improve the lease. Also, we put a lease agreement together that showed them, here's a legal form that you can use, and you can find one on most extension sites, especially at the land grant universities. And it will allow you to say, I need to put a formal lease with whoever is leasing my property with together, and for you and the family to protect your. Also making sure that they get insurance from that particular person who's leasing it. We talked about providing hunting income, that they can go out and find someone to bid, get hunting rights on the property, and that's an annual income they'll make. We even went down as far as trying to make sure all the family members got the same message, and they were successful in getting the farm and getting the actual financial assistance from the USDA. So our next step is to complete the forest management plan and help them work up a business plan to move forward.
Awesome. So this landowner's journey has been pretty dynamic. You know, they've been able to learn a lot, but they've also been able to resolve some issues that were impeding their ability to enhance the conservation aspects of the property, as well as the economic aspects of the property. And they've been empowered to make some pretty important decisions. And this has all been through your work as a forester, but also it sounds like through collaboration with the various agencies and connecting them, the landowners, with those agencies and resource providers.
Yeah, one thing also that was beneficial, we found about 15 acres that was not harvested. And we were able to help them get those 15 acres cleared. We helped them set up an escrow account to hold the money. So now they have a little bit of few dollars to help resolve the legal problem that they're going to be dealing with on the Heirs Property side.
So it's not just about the trees.
Not all the trees.
Yeah. So then this last slide before the resources slide, just thinking about alternatives to solutions that maximize opportunities. So we mentioned earlier that if you have heirs property, the ideal is to get ownership into a single entity owner, because it allows for flexibility and personalization of certain decision making and ownership, and allows it prevents further complicating the ownership structure and enlarging the number of owners who are a part of it. But that's the ideal. And I can say from my experience as an attorney, and I know, Sam, you can say from your experience in working with heirs property owners, is that it's difficult to get to that ideal. You have a lot of different people involved, a lot of different people with different issues or needs or interests. And so it is important to think about alternatives, and again, to be clear on what can be done with the various programs through USDA and through the state agencies, and what can't be done. And to also, to the extent possible, try to reduce any potential loss that the heirs property is set up for. For example, in our family, we had 6 owners, and if any one of them transferred their share to a third party, that third party would have the same rights as them and could petition for the partition, the physical division of the land. And if it can't be physically divided among those 6 owners or more, then they would have to force the sale of it, which is usually what the third party is looking for. They're looking to get the forced sale and acquire the whole property. Well, it could be that if you can't get all of the family members to agree to put their shares into the trust or LLC, you could try to accumulate as many as possible to put their shares into the trust or LLC. So what I'm saying is you could still have the trust or LLC and just endeavor to get as many of the family owners or as much of the ownership shares or proportion of ownership into the trust or LLC, because what that does is it makes the property undesirable or less desirable for that forced sale. I had a family who, unfortunately, I wasn't able to help, but they had over 70 owners, and a neighboring commercial farm purchased 1 or 2 shares of the property. So they didn't have a huge stake from a financial perspective in the property, but because of the number of owners and the complexities of the fractions of ownership, that farm was successful in getting a forced sale of the property and buying the property at auction. So I'm probably harping on the point a little much, but even if the ideal doesn't work from a legal perspective, it's still important to try to find some alternatives in between the current circumstances and the ideal. And then it may mean that you have to restructure your timeline and how, and the different activities that they're going to do in their forest management plan, because as Sam pointed out, some things do require that you have clear title or require some other thing related to the title. And then invite flexibility. Plans may change, so it's important to be flexible and to understand that heirs property is very dynamic and it's not straightforward. And so being flexible can allow you to help people in a very meaningful way, particularly when it comes to increasing the economic impact of their and conservation impact of their land. Sam, before we go to the Q&A session, is there anything you want to add?
No, I just think it's important that try to keep your fight out of the court and do it within yourself, because the minute you try to go to court with a problem, the judge is not going to do anything to try to solve it except probably push it to be sold. So it's easy to work on the problem amongst yourself before you go in before a judge to have them make a decision on your behalf.
Yeah, I love it. So Robert, is it all right if we move into Q&A, or is there something you wanted to?
No, it's perfectly fine. We'll move into the Q&A now. Just want to remind folks that the resources on the last slide that that with all the links and everything is available on the portal's webpage for this webinar, so you can get directly to those links there. Since the handouts are PDF files and they won't be able to see them. We do have several questions that have come in.
Okay. I'm taking a look at some in the chat and then that are related to the sample family. I'll respond to those, and then I'll respond to the ones that came in prior to the webinar, and then pick up the other ones on the Q&A. Is that cool?
Yep, that sounds good. So we can start with those that are in the chat.
Yeah.
From Paul Kennedy.
So Yeah, so Paul Kennedy asked what would happen if George's will had, or if George had a will. So George was the child of William and Mary. He died as an infant. I think he may have meant William Sr. perhaps, or William, or anyone. So if anyone owns real estate, transferring their share. If we're talking about William Sr., the title was just in his name and not him and his wife. And if he had a will donating to the property, well, then that would be the end of the family property. I don't know if I understood your answer correctly, but if anyone transfers their shares to a third party, it doesn't matter if that third party is an entity and not a human. That third party could become a co-owner, or depending on the circumstances, the full owner. Butch Crane asked, he said, if I understand correctly, William Sr. left intestate interest to William Jr. No, that's not correct. In this scenario, we were applying North Carolina law, which you may not be familiar with, but in North Carolina, in this scenario, he and his wife owned the property, so there's an automatic right of survivorship, and so when he died, the full ownership went to the wife. She also died intestate, so then it went to the four children. And yes, Louisiana is different. Texas is different. It's amazing when you look at these states who have strong common law background. It's just different. So I think only recently, for example, in Texas, only recently did wives get to take in some things that they weren't previously related, or able to take in, and that had to do with some gender-based old laws. And then, okay, sorry, that's okay. Okay, so then if you form a trust, can someone outside the trust challenge it? If so, on what basis would they likely do it? So anyone can form a trust. You can't, I don't know why you would challenge someone in creating a trust, but if your question is speaking to whether transferring the ownership interest into the trust could be challenged, yes. If you don't have clear title, so if by clear title, we know who all the current legal owners are. We also know whether there are any claims on the property, whether that's claims of an ownership interest or claim of a secured interest or anything like that. That's what I mean by clear title. And yes, if that hasn't been done properly, then it would be a huge issue. And so some people skip that step of clearing title and they go ahead and transfer it into an LLC and think that that clears the title. It does not. All right, so let's go to our questions. We invited folks to send some questions in prior to the webinar, and I'm speaking quickly because I want to make sure we get to the other questions in the Q&A. So forgive me, and Robert, if you see that folks want me to slow down, just tell me. So one question came in, and it said, if there are 1,000 heirs of varying degrees, what is the raw number or percentage agreement required to transact legal business? Example, cutting timber, leasing land, securing a tax ID for banking. So disclaimer again, I'm not a lawyer in Arkansas. I'm not licensed in Arkansas, but the case for most states is that it requires unanimous agreement. So it's not about how many of the 1,000 heirs have to agree. It's whether you can get all 1,000 of them to agree. As far as getting a tax ID for banking, though, if you form an entity and seek a tax ID, you can do that. That has the ownership of the land has no bearing on getting a tax ID. The next question we had is there a resource or registry of lawyers in Arkansas that specialize in LLC or trust setups for heirs property? I do not know. I know that the University of Arkansas at Little Rock was affiliated with the University of Arkansas Pine Bluff program on sustainable forestry and African American land retention, which I'm also a part of. I don't know if they are continuing to work with heirs property owners now, but they could be a good starting point to find out who would be a good person or law firm to reach out to. Another question was, once the LLC or trust is set up, how does it prevent or how can further heir confusion be avoided regarding share ownership and transfer? Well, the great thing is that it's all documented. It's in writing. So you will have a clear title report from an attorney that's documenting ownership. But once that ownership is transferred into the single entity, you're not trying to determine who the owners are going forward of the land, because the land will continue to be owned by the entity. Instead, you're determining who owns the LLC or who's the beneficiary of the trust, and that will be in writing. The LLC operating agreement, and this is one of the reasons why it's so important to have one, it sets forth how succession happens. What happens when a member/owner dies, who gets their share, and how can new people or new members be added, or how can people be removed. So it really depends on how that LLC is set up, how the operating agreement is set up to what confusion. So if you try to set it up yourself, it's probably going to be confusing. You had some specifics around that scenario, but hopefully what I explained made sense. And then there's a third question: what if one heir refuses to pay taxes and the others cover all expenses? Well, you are explaining the nightmare of many heir property owners. There's always busters. Either they're busters, or you just can't find them, or they're children, or whatever. But again, it could vary from state to state. But generally speaking, if any owner does not pay their share of the property, it does not. Their share of the property taxes or any expenses is covered by another owner or owners, that does not enlargen the paying owner's share simply because they're paying for someone else's responsibility. It does, however, create a lien on the non-paying owner's share. So when the property is sold, if the property is ever sold or if it gets any income, then you can seek reimbursement from that income. But unfortunately, you would have to do that through the court, through like a small claims, likely a small claims proceeding. And then someone asked how and whether the Uniform Partition of Heirs Property Act has helped. So the Uniform Partition of the Heirs Property Act is legislation that has been developed and adopted in 20 states. So that's really tremendous. 20 out of the 50 states have adopted this already in the last 7 or 8 years. And this legislation provides extra due process rights in partition actions that involve family-owned land, that involve heirs property. And so it's pretty powerful that 20 states have adopted this and have created a mechanism for when land that's owned by heirs property is considered for physical division or for sale. It puts more rights in there. It also requires fair market value. It's pretty significant. But in answering your question, in terms of how it's helped, I will say that there's not a lot of or any data on how many partition actions have been done under the Act, or data about how much land has been sold through a property act, a partition act in a state that has adopted that. So that data is not there. We do have some anecdotes that say that at a minimum, in states where they have adopted the act, it has served as a deterrent to third parties seeking to buy heirs property and force the sale of it, because they know that they're going to have to pay the fair market value at least. So it serves as a deterrent. And then the other great thing that has happened with the adoption of the act is that for the first time in U.S. history, the Farm Bill has included provisions for heirs property owners. Sam mentioned one of them, which was that in states that have adopted the Uniform Partition of Heirs Property Act, here is the process for obtaining a farm and tract number. That did not exist before. And of course, that's for states that have adopted the act. States that have not adopted the act, the process for them obtaining the farm and tract number has not yet been defined because the regulations for the 2018 Farm Bill have not been released 2 years later. But yeah, I think that the adoption of the act has been effective for a few reasons, and I think that the effect of it will continue to grow. So moving on to the Q&A chat board, Butch asked, can trust beneficiaries be changed over time? Yes, and they should be. And ideally, you will create a succession plan for beneficiaries. You could have the current beneficiaries are the owners who transfer their shares, and then the subsequent beneficiaries are blood descendants of either their original owners or theirs. Brian Townsend said, I understand trusts are difficult to change if tax laws change and require going to court. So irrevocable trusts are very hard to change, and I don't recommend putting heirs property into an irrevocable trust. An irrevocable trust means what it says. It cannot be revoked. There are very limited circumstances in which it can be revoked. So it should definitely not be an irrevocable trust. How protect against non-family member in a divorce? Good luck. This is why people sleep on prenups. Prenups are not just for wealthy people. Prenups are very effective for helping maintain family wealth that you want to stay in the family line. So do not sleep on prenups. But, you know, if we don't have a prenup in place and we have a divorce, well, I don't do family law, so I'll just say that. I don't know. Like, it's supposed to be separate property, but I think some circumstances could create a situation where that property is subject to the divorce. I don't know. Mike Dukes asked, can the same acreage be enrolled in two different, this is for you, Sam, can the same acreage be enrolled in two different programs? For example, can the same 20 acres be used in the forestry program and the EQIP program?
When you say the forestry program, are you talking about applying for money from the state agencies? If that's the question, then the answer would be no. Because if you get funded under EQIP, I don't think you'll be able to get funded under the forestry program. And you would want the funding under the EQIP because it pays more.
Chris Pickler asked, what role, if any, do you think land trusts can play in working with heirs property owners? So in this case, you're talking about conservation organizations to conserve and protect land for, you know, like clean water and habitat protection and so forth. I think they can play a big role. A lot of these land trusts have really great relationships with other conservation organizations, so they can serve as a partner, but they can also serve as a connector. They can also consider how their conservation can increase interest in land, real estate around their properties. You know, are you creating a green nuisance, as I would call it, by having a beautiful nature preserve near a downtown area? Well, yeah, you are necessarily going to drive the market pressure up. And for heirs property owners, that could actually be a negative, because all you need is one person to come in and buy a share and then force the sale of it and get it for less than market value. So land trusts can enforce, they can also influence policy, you know, since they're advocating for protection of land. Protection of family land is very important to the conservation movement. Robert, I just want to check in about time. I know it's after 2. Can I continue to answer questions?
Yes, we're good until
Okay.
2:30.
Okay, great. Steve Anderson asked, does a majority number of shares give a group right to access government programs? That's kind of a Sam question. I can say that the provisions in the Farm Bill 2018 around the heirs property land, it sets out what's required to obtain the farm and tract number. And one of the options is a majority share of owners giving authority to one of the members. Sam, do you have anything to add to that?
Yeah, the key piece of that is that who's responsible for the tax bill. So if X is getting the tax bill, and sometimes if they live on the property and they are able to show that type ownership, it will allow them to apply for the farm and tract number. What it will not allow them to do, there are certain programs that requires an actual clear title. One being on some under the Farm Service agencies, but also under the environmental quality, under the NRCS, a person or a landowner that has no clear title cannot apply for the easement program. Nor could they borrow money against the property if they don't have the clear title as it relates to USDA.
Okay, so Joseph Whitaker asked, how can we get clear title if the property was left equally to 5 children, 3 of whom are getting along, 2 of whom are not going to assist? Well, one, work with a lawyer, and I don't know what state you're in, but I'll answer generally. I would say that so in terms of getting clear title, I'm guessing that the 5 children became owners through inheritance from a parent, and all you would need is, well, it depends on when the parent died, but, you know, one thing could be administering the estate of that parent who left it to the 5 children to create a legal record of who the 5 owners are. If you're in a state that permits heirship affidavits, you could, again, you know, with the help of an attorney, you could file an heirship affidavit or record an heirship affidavit that demonstrates, you know, it's a sworn statement saying Mary Sample owned this property, you know, based on this deed and the deceased husband, and she died on, you know, in insert year, and these were her heirs, and they are the owners of this property. So you could do that to quote unquote clear title and create a public record that shows the clear title. But then in terms of doing action on the land, I would recommend that the three owners who get along put their shares into a single entity owner, because what that's doing is saying that 3/5 of the property, if anyone seeks physical division, 3/5 of the acreage will belong to that entity, and that's significant. And then I would also try to ascertain the value of the other two owners' shares and consider buyouts. Is it possible to get a buyout? And you may have resources to get money, but there may be resources out there to help you do the buyouts, but you could also consider seller finance buyouts. So by that, I mean that the two sellers would agree to sell their shares to the other owners and finance that sale. And so it's kind of like having a deed, or a mortgage on the property, but that mortgagee is the seller. So that's an option to get out of, get them out of the picture. But I will say people are petty, and some people will swear that they're not going to do anything because they don't like you or whatever, because you made them mad when they were 9. So then you're thinking more about resiliency and mitigation of risks. Greg asked, will you be able to post links to any handouts? Yeah, so as Robert mentioned, he did put a link in the chat box as well. There will be links, I think, on the website afterwards. But as far as, some handouts. Yeah, that's a great question. There is a lot of material out there. I'll have to think about that, but could you email me, Greg, and possibly we can come up with something, a handout with information for landowners, for heirs property owners. I'd be happy to help. So then Sean asked about the trust setup. You said an operating agreement. Oops, it moved. You said the operating agreement of the LLC should handle, what about trust? So the trust document, so in your handout, there's a sample trust document. The trust document for the family land would be much more nuanced and tailored to the family, but the trust document would address those things. So with a trust, you don't have an operating agreement. You have like a settlement agreement. It's a trust document. Kind of like with the will, you have a will. It's like a trust document. How do you get a third party to agree to clearing title and placing the property into a single entity? You mean a third party owner? Oh, wow. Okay, so non-blood relative. How do you get a non-blood relative? Let's frame it that way, to agree to clearing title and placing it into an entity. I would refer back to my previous answer. I think it's important to, before you approach folks, to map out who the owners are and highlight the positive relationships that you have and the negative or challenging relationships that you have. Try to reap the rewards sooner, like on the front end, try to get those who are cooperative to go ahead and do what you're asking them to do by putting it into the entity, and then think about different ways you can resolve the issues with the other owners who you either don't know or who aren't cooperating. I like the strategy of cash during important holidays like Christmas, offering someone some cash near Christmas might help them just agree to sell their share. If farming is done several decades ago on your property, are you still able to apply for a tract number, farm and tract number from FSA and receive EQIP funding? Sam?
Yes, yeah, farm records are pretty much established back in the day, and they can help you once you take a copy of your deed or the tax record and a map. They can help establish a record, and you would take it to the Farm Services office, and most likely they have a record, but it may not be in your name. It may be in the previous landowner or the deceased landowners.
Yeah. Fran, hey Fran. Fran asked, how does it help to have a portion of the property in a single entity and the rest in single shares? How does it make the property less vulnerable? So typical lawyer answer, which you'll understand because you're a lawyer as well. It really depends on the situation. So let's say Sam and I own the property as siblings and we each have 50%. Well, putting 50% into a single entity and Sam, who's not cooperating, doesn't put his 50% in, we still have the same circumstances in that you still have to get unanimous vote on decision making. But let's say that we throw Robert into the picture and we each have 30, or how do you divide 100 by, whatever, 33.3333. We each have a third. I could do the fraction. Sorry, why am I trying to do decimal points? Let's say that we each have a third, and Sam, again, is being a buster, but Robert and I get along. Well, now we have 2/3, yes, 2/3 of the property ownership into a single entity. And let's say that we are dealing with 100 acres. Well, having 70 acres, I think, or 70% of that acreage in the, sorry, I should stop. I should stick with one numerical thing. This is why I have a mathematician that works with me. Okay, we have 2/3 of 100 acres in a single entity. Well, if Sam, or even if Robert and I, as owners of the entity, decide to petition for a physical division, a majority of the land will be owned by the entity. So it really depends. It's really a game of numbers, like understanding the value of each owner's share and understanding how that, whether that can offset the risk of loss of acreage, or whether it could deter a third party from seeking the forced sale. You know, going back to that example I said before, where you had two owners who were third parties by chance, not by chance, because they bought shares. They owned 2 shares out of 70 some owners. And so the value of their share, the proportion of their share, was so much smaller than the rest of the shares. So if all of the other owners agreed to put their shares into that single entity owner, then when the clerk was considering whether or not the property could be physically divided, they had no choice but to physically divide it rather than sell it. But in this case, what happened was that you had all of these different owners with crazy fractions, and the clerk had to force the sale of it. SRW says, many of them are 3rd and 4th generation and have never been in the state in which the land is located back, nor are they interested in the land. Also, there are many who aren't even aware that we have heir property. I've tried gathering info from these heirs to complete details of our family tree prior to getting an appointment with an attorney to set up a trust. What happens if I cannot get in contact with the heirs? Well, I think the first thing before you do that is that you need to get legal confirmation of who the owners are. I'm going to assume by your question that you have gotten confirmation of who the owners are. And then in terms of getting contact with them, again, I would start with what rewards can we get? What rewards can we accomplish right now? So to the extent that you know who owners are and you are engaged with them and they are willing to put their shares into the entity, you can go ahead and start doing that because we're trying to limit the risk or minimize the risk of loss or partition. And then for the folks that you find, let's imagine you just can't ever find them, then you can seek appointment of a guardian ad litem to take care of their share. And you could even consider taking some sort of action, such as an adverse possession action. So don't want to get too deep into adverse possession, but you could do a court action in which you're saying, we know these owners over here, we know these people, we haven't identified them, we can't find them, or maybe we've identified them, we can't find them. And we've been taking care of this land, they haven't been taking care of the land, and we are entitled to own their shares because we have treated it as our own. I'm simplifying what that sounds like, but that would be a potential strategy that I would consider for that kind of circumstance. If the property, so another question from Carl. Carl says, if the property could be set up as an ag, forestry, tourism business, any thoughts? I love that idea, and I think that's a reality for many ag landowners. You have to have diverse streams of income.
I actually have several individual landowners or family landowners that have targeted and went that way. And
yeah,
the whole forestry plan help create the business plan for them to show them that there's multiple opportunities that they can generate income from the property, and it led them to either set up a trust or set up an LLC, which also led to bringing other family members, the younger generation, into that business model with them, and it helped them to kind of keep the farm.
Mm.
Yep.
Mm-hmm. SRW, just to follow up on your question about the 1,000 heirs, you know, the approach may be that you are confirming who you can and what their shares are, and then that's what you're demonstrating to the court, that all of these people who we have been able to confirm are the owners and have been doing what, you know, et cetera, taking care of the land against the interests of these unidentified owners who haven't been engaged. Karen Lee, hey Karen, how do you deal with a squatter that has been on part of the land for a while and now claiming that property? Well, it sounds like they're trying to claim adverse possession, and my answer, of course, depends. And I know you're in Arkansas, I'm not licensed there, but generally speaking, if someone's squatting on land and they're trying to claim it, and you've known about it, and you know, have continued to do what you're supposed to do with the land, they probably don't have a strong case for adverse possession. I would immediately, though, I would erect some fences, some boundaries, some what's that stuff called? The kind of fence that pokes you? I don't know. I would start putting up some trespassing sounds. What's it called?
The purple boundary paint.
So,
yeah.
So posting the property,
Posted the property with no trespassing. But also, let me add something to this conversation. People, you may not live on the land, but you want to always have an annual check of the land. I want to put a plug in for either the consultant foresters, or just hire a forester or someone to go out and verify that you don't have those poachers, or you don't have someone living on your property, or no one's cut across the line and stole your timber, or you don't have a fire hazard or a forest health problem. So it's critical. If you budget a little money, put it to the side, at least pay for that service once a year, it'll save you in the long run.
All right. So Anonymous said, is one type of arrangement better when there are multiple family member owners and one wants out and the others don't want anyone outside the family to acquire part? Well, with the trust, the creators of the trust set out who the beneficiaries can be. They can provide the beneficiaries, and I think the trustee even with powers to determine who the beneficiaries are. With the LLC, the LLC operating agreement dictates how that happens. And so that's why it's important to have that operating agreement, because if you don't have an operating agreement, you default to the state laws. And, you know, the state laws vary from state to state, but it could impede your ability to address that issue, you know, in terms of which choice of entity. All right, so then going back to the chat box. How do you deal with the squatter? We talked about that. Okay, it's not SRW. Yeah, SRW, adverse possession. I would talk to a lawyer about adverse possession. Mary, who is the best person to give advice about single entity owner options and related issues? That's a great question, because we didn't talk about working with a lawyer. It is important to work with a lawyer who, first, is working in the area of law. So this includes a person who is familiar with estates, with inheritance laws, who's familiar with tax laws, who is familiar with business law. And I recognize that it can be hard to get all of that in one person. So it may be that you're looking at a firm as a whole, you know, firms that have business lawyers, real estate lawyers, you know, estate stuff, so that they can tag team. It is very difficult to find suitable lawyers, or, you know, lawyers with the skills to do this kind of work. Another thing to consider is whether the lawyer's approach to working with family land is simply a resolution. Because what I've seen among my peers is that to say, oh yeah, I work with heirs property, I do partition sales all the time. I'm like, that's not what we want. That's not what we need in terms of keeping the land in the family. We don't need attorneys who focus on, okay, here's family land, let's do a partition, let's divide it, let's do a sale. That's not speaking to any of the values that Sam and I have discussed in this webinar or the previous one. So I think it's important to interview attorneys. I think it's important to ask them, you know, what their approach is when it comes to family land, to find out if they immediately go to division or partition sale. I think it's also important to see what kind of skills they have and experience they have in working with those kind of issues.
Even down if you can ask
Robert,
for references.
Yeah. Robert, did you see this question about CFEs?
Yeah, I already responded to that following.
Oh, okay, cool.
Actually, you have a question towards the bottom from Corolla Haas.
About nonprofits?
Yeah.
Okay. Yeah, so are there nonprofits that will help cover the cost of the initial legal consultation? Seems like this could be a huge barrier to families. That's right. It is the cost is a huge barrier to families. When I was doing this work as a lawyer, it was quite disheartening, you know, to talk to families who had to choose between paying their property taxes and paying me. Certainly didn't make me feel good that, you know, I couldn't work with them until they had money. But I do think that's why strategy is so important. I think it's important to be clear on what your goals are and what the alternatives to those goals might be. And then also be clear on what your threshold is from a financial and emotional perspective. Because if you know, for example, if you know that you have maybe $2,000 to invest in clearing title, then it's particularly important for you and any attorney that you consult with to understand what the boundaries are of the work that they're going to do, and that it doesn't go beyond what you're able to invest, and that it gives you the opportunity to pivot and do something different. And so what I've done, or what I did in the past, was I would agree to do a consultation. Attorneys are able to set create a consultation, say, I'm going to do a 2-hour consultation, or I'm going to do a 3-hour consultation. This is how much it's going to cost. And then this is what I'm going to do. For, you know, if we're starting off, if we don't have clear title, and people may believe they have clear title, but don't actually have clear title. But if we're starting off and don't have clear title, then the goal is the family has to provide me with a family tree as best they can from the original owners to the present. And then, of course, the advance fee deposit or the retainer. And then I agree that I'm going to review the available public records, so the records with the deeds of trust, GIS, whomever, and the family tree, and provide an estimate of who I believe the current owners are and how many current owners I believe, and what are some of the issues I see with clearing title completely. And then that I'm also going to make recommendations for next steps. So to give you an example, I had a family where the land was purchased in 1915, and the last deed of record was 1915. And like many people in the country, I'm from the country too, so I can say this, they had a lot of kids. So the original owners had about 12 kids, and then each of their kids had about 12 kids. So the family was huge. And then for whatever reason, many of the family members died at a young age. So within 5 hours of reviewing all of the paperwork, I was able to see that they had many owners, and able to say to him, if you want to pursue your goal of getting ownership in your name, this is what the hurdle will be. You will have to litigate this, and it's going to cost you at least $10,000. And he was able to make an educated decision and say, I can't do that. I'm backing out. And he had only invested $1,500, not only, but he had invested $1,500 as opposed to just racking up fees and then not having any kind of informed path forward. I do think that nonprofit law firms, legal aid or whomever, I think they're great. But I think it's important that you invest what is needed if you can to get the consultation that you need. And so it just requires that you're pretty strategic about, you know, how much time the lawyer is going to spend and how much it's going to cost them to do that before you actually pay the money. Are those all our questions?
That is it.
That's it.
And
So-
at 2:24, we just had thank yous.
Yep, I'd like to thank both Mavis and Sam for the effort to put this together. This was a follow-up to a webinar back in May. So if you did not have a chance to participate in that webinar, it is on demand, as well as this one will be on demand here within a few days, so that you can share it with others. We'd appreciate that to help spread this information, which is very valuable. And so with that, Mavis and Sam, thank you very much for taking your time today to do this.
Thank you.
Thank you.
This was great. Thanks to all the participants. And
Thank you.
remember, watch what you're doing and get this clean, clear title and spread the word.
Spread the word. Amen.
Yep.
Bye, y'all.
Take care, Bob, and see you later, Mace.
All right, thank you all. That'll be it for this webinar. Bye-bye.